The Iowa State Bar Association's Committee on Ethics and Practice Guidelines presents a discussion of Rule 32 titled Dealing with Conflict Cooties, given by Nick Critelli, Committee Chairman. To introduce the concepts, let's look at a short video titled The Doctor's Diagnosis, in which a lawyer is examined by his doctor.
This is strange. Have you been in contact with a client?
Not that I know of.
Okay. How about a potential client? Someone you talked to on the phone or the internet? Maybe they gave you information or you gave them advice?
No, I don't think so. I don't use Facebook. In fact, I don't think that I use any social media sites at all.
Let's see. Have you formed a relationship with a fellow lawyer who may have done any of those things?
No, I've always been a sole practitioner.
Okay. Well, are you of counsel for any other law firm or lawyer?
No.
How about a contracted lawyer? Have you used a law type agency to get help?
No, but that actually sounds like a very good idea.
This is most unique. Those are the most common situations. There must be something else that caused this. Let's see. It's summertime. Do you have a summer law clerk?
I actually do. In fact, she's one of the best students that I've ever had. You know, she's really brilliant. In fact, in my practice, I don't know what I would do without her.
Yes. I know, our med students keep getting better and better. Do you know if your law clerk was involved in a clinical program with her law school or if she clerked with any other law firm?
Well, actually, now that you mention it, I believe she was in the clinic in the law school. You know, the law schools are using more and more clinical teaching methods. I think they're trying to give students more practical skills than they used to in the past.
Okay, that's it. You have conflict cooties. And
what?
And it looks like you got it from your law clerk.
That's not possible. I have no contact with her.
I know it's hard to believe, but it happens.
No, doctor, really, there's got to be a way I can get rid of this. Tell me, there's got to be an antidote or some medication that I can take or a treatment.
Not really. There's no cure. Once you've got it, you've got it.
There's got to be something I can do. I mean, surely there's some sort of Chinese remedy, an alternative intervention. I mean, I'm willing to work with anything, doctor. I mean, just give me something that I can hang my hat on.
I don't think so. The Chinese cure works in some states, but it is really complex, and I think you need to see a specialist. And remember, contagious right now. You've got conflict cooties.
Each day, thousands of lawyers go to their office only to find that they've been infected by conflict cooties. It's not if this could happen to you, it's when will it happen. There's no known cure and only one vaccine, a waiver, but it is only effective in a small number of cases. The best cure is prevention. Now, in this public service announcement, we're going to show you how to recognize the various types of conflict cooties and how you can build a practice that is cootie-free. First, to avoid them, you must understand them. Now, the most common variety is the direct conflict. It's called direct because it exists by virtue of a contact between a lawyer and two of something else. For example, two clients, a client and a third party, or even the lawyer's own interests. So let's learn some more. Suzanne?
Rule 32, 1.7. Conflict of interest. Current clients. A. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer. Comment 8. Identifying conflicts of interest, material limitation. 8. Even where there is no direct adverseness, a conflict of interest exists if there is a significant risk that a lawyer's ability to consider, recommend, or carry out an appropriate course of action for the client will be materially limited as a result of the lawyer's other responsibilities or interests. The mere possibility of subsequent harm does not itself require disclosure and consent. The critical questions are the likelihood that a difference in interests will eventuate, and if it does, whether it will materially interfere with the lawyer's independent professional judgment in considering alternatives or foreclose courses of action that reasonably should be pursued on behalf of the client. Rule 32, 1.9, Duties to Former Clients. A. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or a substantially related matter in which that person's interests are materially adverse to the interests of the former client, unless the former client gives informed consent confirmed in writing. B. A lawyer shall not knowingly represent a person in the same or a substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client. 1. Whose interests are materially adverse to that person, and 2. About whom the lawyer has acquired information protected by the rules 32, 1.6 and 32, 1.9c. That is material to the matter, unless the former client gives informed consent confirmed in writing.
Many good lawyers have become infected by these four little words. Tell me what happened. Once the answer starts, you're infected. The good news? We're winning the battle against direct conflicts. Legal education in combination with the computer have made it easier to detect client conflicts. The key is to use an interview tool known as a CHELP memo. CHELP, C-H-E-L-P, is an acronym for Conflicts, History, Evaluation, Limitations, and Plan. Notice that the first item is C for conflicts. Now here's how it works. In your first meeting with a potential client, by using CHELP, you will first talk about potential conflicts. Only after you have cleared the conflicts barrier do you ask the question, tell me what happened. Never, ever get information from a client until you have satisfied yourself that there is no potential for a conflict. Remember, the conflicts between present and past clients and even third parties are easy to discern at this point. However, what is not often apparent is the potential for a conflict between your interests and the interests of clients. These can arise at any time, especially if you find yourself in a position where you have to defend your work. Now, here's a simple way to identify a potential personal conflict. If your work product is being attacked, or there's a potential for an attack, seek outside advice. You may be infected. Now, some current news. A strain of Conflct Cooties has developed that is resistant to traditional detection. It's known as the prospective client conflict, and it is being spread by the internet and social media. So let's learn a little bit more about them. Suzanne?
Rule 32, 1.18, Duties to Prospective Client. A person who discusses or consults with a lawyer about the possibility of forming a client-lawyer relationship with respect to a matter is a prospective client. B. Even when no client-lawyer relationship ensues, a lawyer who has had discussions with learned information from a prospective client shall not use or reveal that information learned in the consultation, except as Rule 32 1.9 would permit with respect to information of a former client. C. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or a substantially related matter if the lawyer receives information from the prospective client that could be significantly harmful to that person in the matter, except as provided in paragraph D. If a lawyer is disqualified from representation under this paragraph, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such a matter, except as provided in paragraph D. D. When the lawyer has received disqualifying information as defined in paragraph C, representation is permissible if 1. Both the affected client and the prospective client have given informed consent, confirmed in writing on 2. The lawyer who received the information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether to represent the prospective client. And I. The disqualified lawyer is timely screened from any participation in the matter, and is apportioned no part of the fee therefrom. And I. Written notice is promptly given to the prospective client.
So, how do you protect yourself? Let's take a brief look at some legal history. Very, very old lawyers used to use a phrase in reply to a request for curbstone advice. They would say something like, "You must approach me in the proper way." Now, this was an old-fashioned way of saying, "You must talk to me at my office." Later I learned that the root of the phrase went all the way back to English barristers. Until recently, a client wishing to talk to a barrister could only do so through a solicitor. When asked for advice, the barrister would say that they must be approached in the proper way. Now, you wouldn't want to talk like that today, but the concept is still good. When asked for advice, whether on Facebook or other social media, that's the modern version of the curbstone, simply say that for confidentiality purposes, you can only advise from the office. Once they come to the office, you can conduct a proper interview. Now, don't solicit or encourage questions on the internet. It's just like asking the world, "Tell me what happened." Unilateral, unsolicited information is not protected, provided you don't encourage it. But what about the client who's shopping around? How do you protect yourself during an in-person interview? At the start of the initial interview, when you're dealing with the C in CHELP, always tell the client what you were doing and why you're doing it. Tell them not to tell you confidential information until you have cleared them for conflicts. Further, tell them that there's no expectation of confidentiality until they're cleared. You could go even one step better and put it in your letter confirming their appointment. That way you've got a record of it. Remember, this is for their protection as well as your own. They're entitled to conflict-free representation and to have their information kept confidential. Okay, now there's one more variant of conflict cooties that we need to discuss. It's called the hopper. It's called this because this variety of cooties hops from one law firm to another. So let's learn some more. Suzanne?
Rule 32 1.10. Imputation of conflicts of interest, general rule. A. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rule 32 1.7 or 32 1.9, unless the prohibition is based on a personal interest of the prohibited lawyer and does not present a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. B. When a lawyer has terminated an association with a firm, the firm is not prohibited from thereafter representing a person with interests materially adverse to those of the client represented by the formerly associated lawyer and not currently represented by the firm, unless 1. The matter is the same or substantially related to that in which the formerly associated lawyer represented the client, and 2. Any lawyer remaining in the firm has information protected by Rules 32.1.6 and 32.1.9c that is material to the matter. C. A disqualification prescribed by this rule may be waived by the affected client under the conditions stated in Rule 32.1.7. The disqualification of lawyers associated in a firm with former or current government lawyers is governed by Rule 32.1.11. Comment 2. The rule of imputed disqualification stated in paragraph A gives effect to the principle of loyalty to the client as it applies to lawyers who practice in a law firm. Such situations can be considered from the premise that a firm of lawyers is essentially one lawyer for purposes of the rules governing loyalty to the client, or from the premise that each lawyer is vicariously bound by the obligation of loyalty owed by each lawyer with whom the lawyer is associated. Paragraph A operates only among the lawyers currently associated in a firm. When a lawyer moves from one firm to another, the situation is governed by Rules 32.1.9b and 32.1.10b.
Firm hopping or imputed conflicts are becoming very common. Remember, they will always come from the outside and usually by a new hire. That person can be a new lawyer or even a law clerk. Okay, now, there are two types of imputed conflicts, direct and indirect. The easiest to detect is the direct variety. This happens when the new lawyer was directly involved with you or another member of your law firm on behalf of a client. Absent a waiver, there's nothing you can do in this situation. An indirect conflict arises when the new lawyer was not involved in the conflicting matter but was only a member of the law firm. The new lawyer becomes infected because of the association with the prior firm. Secondly, the new lawyer will not be involved with that matter if hired. In this type of situation, a so-called Chinese wall between the new lawyer and the conflicting matter may be possible, but this is very complex. Now, do not attempt to build a Chinese wall yourself. Always use independent outside ethics counsel. Let them determine if a Chinese wall will work and let them build the wall. In fact, my advice is always use outside independent counsel when you are seeking a conflicts waiver of a direct conflict or building a Chinese wall. Advice of independent counsel will give you a credible defense if you're ever attacked. Well, there you have it. Forewarned is forearmed. If you have any questions at all, please drop me an email at nick@critellilaw.com, nick@critellilaw.com. And remember, only you can prevent conflict cooties. This is Nick Critelli in Des Moines, Iowa. Thank you.